Hello. It's always a great pleasure to be back here at my alma mater, and particularly grateful to Dean Minow for asking me to talk about my favorite topic, which is investment treaty arbitration, a topic which I will say was not on anyone's agenda when I was here sitting where you are sitting today. When I left this law school in 1989, which I will say is when dinosaurs still roamed the earth, the only way you could pursue a career in public international law was either by trying to get one of a few very rare positions in the State Department or in international organizations, or by taking a job in private practice and hoping you could, along the way, cobble together enough of a plate of cross-border deals, cross-border litigation, commercial arbitration, to give you a flavor of international practice. I spent a summer at State, but I ultimately pursued the second path. And for my first 8 years in private practice, I was a general litigator, trying to cobble together as much of a career as I could in an uncertain environment for public international law. But in 1998, I stumbled upon the field I'm going to talk to you about today. And at the time, this was an incredibly obscure field. So much so that I first heard about it actually in a lateral job interview when someone said, "What do you think is the future of ICSID?" And I had never heard the acronym ICSID, and I had no idea what its future was. And I faced that awful job interview choice. Do I try to fake it through the interview, or do I admit my utter ignorance? And what is the path of least risk? Better, I thought, to come clean, to admit I had no clue what they were asking me about. And I did, and fortunately that wasn't the end of the job interview. But that turned out to be one of life's completely unplanned forks in the road, of which you will have many, because today the bulk of my work, both as arbitrator and as counsel, is in investor-state arbitration, including at ICSID, an acronym that I'll explain in a minute. So I spend my life basically flying around the world doing public international law. But the change in this field from obscurity to prominence in just a couple of decades, the same journey that I have taken personally in my career is very much true of the field as a whole. It was a relatively small and unknown area of practice, and it has become in recent years front page news. It's become even fodder for television drama and late night comedy. And to prove that I'm not exaggerating, because you wonder how could anything so obscure be fodder for late night comedy, just a few pop culture references to illustrate the point. So I never watched The Good Wife. I actually don't know the series, but in the 2011 season, Senator Fred Thompson popped up on the show, and he explained that the Venezuelan government had just nationalized an oil drilling company. And one of the show's main characters announces, "We just filed a suit contesting this nationalization before the World Bank's ICSID Center, and we're trying to get them to assess a value for the company." And the show then cuts to a scene of Hugo Chavez, who's trying to change the law so that there can be no fair market assessment of the company that's been nationalized. And he says, "I have the power to do that anytime I consider it to be necessary to protect the interests of the Venezuelan people." And the hero of the show then says, quote, "It's like being in a Woody Allen movie." For the few handful of us in the audience who actually understood the references, the real question is, how the heck did that make it onto television? And where are the arbitrators to sort out right from wrong? So cut forward about 4 more years to earlier this year, when John Oliver spent 20 minutes on late night television ripping into Philip Morris's threat of lawsuits against Australia, Uruguay, and Togo. This all had to do with challenges to cigarette plain packaging laws, which require the display of health warnings rather than brand logos. And Philip Morris in these cases was contending that those kind of requirements would reduce the value of the brand's trademarks and intellectual property, and therefore was a taking of its intangible property rights. And John Oliver expresses shock that a company could actually sue a government, and he thought that was really creative, but rather evil.
India's legal troubles were just beginning, because then Philip Morris Asia got involved. The company is threatening to take the Australian government to an international court and says that removing brands from cigarette packs will lower the value of its trademark and intellectual property.
That's right, a company was able to sue a country over a public health measure through an international court. How the f*** is that possible? Well, it's really a simple explanation. They did it by digging up a 1993 trade agreement between Australia and Hong Kong, which had a provision that Australia couldn't seize Hong Kong-based companies' property. So, 9 months before the lawsuit started, PMI put its Australian business in the hands of its Hong Kong-based Philip Morris Asia division, and then they sued, claiming that the seized property in question were the trademarks on their cigarette packages. And you've got to give it to them, that's impressive. Someone should really give those lawyers a pat on the back and a punch in the face, but a pat on the back first. Pat, then punch. Pat, punch. They need a pat, punch. Little pat, big punch. That's what they need. But wait, there is more.
Okay, so 10 days after that, investor-state arbitration hits the front pages of the U.S. newspapers. Senator Elizabeth Warren writes an article in the Washington Post where she says that the investor-state dispute settlement provisions of the Trans-Pacific Partnership Agreement, the TPP, would undermine U.S. sovereignty by allowing foreign companies to challenge U.S. laws, to seek large payouts without ever stepping foot in the U.S. courts, but rather putting their case before arbitrators like me. The White House issued a policy paper, which I haven't tried to excerpt on the slide because it's fairly long. But a few months later, President Obama himself took Senator Warren on in a speech at Nike's headquarters, where he said that her warnings were absolutely wrong. He said investor-state arbitration was not a threat to U.S. law, but rather it was a protection against U.S. companies who face discrimination abroad and who otherwise would have no remedy but to submit their concerns to what he called the whims of some government bureaucrat in some other country. So welcome to my world. This gives you a little flavor of how it has become very political. What's it really about? So I'm going to give you a very, very brief overview of what investor-state arbitration is and about its childhood, which is a period of rapid growth. And that brings us to the troubled teenage years that I think the system is in today. And so forgive me in advance, I'm going to go very quickly through the what it is and how did we get here part, just to set the stage. I'd like to try to spend more time on the crisis questions and hopefully have time for your questions as well. But first, for those of you who are not terribly familiar with investor-state arbitration, the place to start is by recognizing that it did not develop in a vacuum. It's a system for addressing what are called mixed disputes that are generated from foreign investment. And traditionally, if you think of the international legal order as having a hierarchy of relationships, the top level of that hierarchy were relationships between sovereign states on the same level of the public international order. Disputes between sovereign states can go to the World Court. And then a step down on that hierarchy, disputes between private actors can go to national courts, or if you have an agreement, to commercial arbitration. But there really were very limited avenues for addressing mixed disputes, a dispute between a private actor and a host state. Traditionally, those could be resolved in only a few possible ways. The investor's home government, protecting its favorite investor, could send warships, gunboat diplomacy, and try to topple the foreign government or force it to change its policies. And that obviously was unfortunately demonstrated to be an available mechanism in a number of cases, but it's hardly a prescription for the peaceful settlement of disputes. More peaceably, there were only two other avenues for resolving mixed disputes. You could have national court litigation, either in the home courts of the investor, if it could find a way to sue the foreign government, or it could submit itself to the national courts of the host state where it had made its ill-fated investment, if it could find fair justice in those courts. Alternatively, it could exercise what's called diplomatic protection, or rather ask its home government to exercise diplomatic protection, which essentially meant appealing to its home government to adopt its claim as its own and elevate it to the level of a state-to-state proceeding before the World Court. Those were the only options. And each of those mechanisms had serious drawbacks. National court litigation raised concern about neutrality in the host state courts. Could a foreign investor get a fair shake from judges who perhaps were appointed by the very same executive branch that they're trying to sue? And it raised problems with sovereign immunity in the investor's home court. There are simply very few avenues to sue a foreign government in national court when what you're challenging are not commercial acts, contractual disputes, but regulatory or legislative or judicial acts, quintessentially sovereign powers. If you think about the US court system, the doctrine, the active state doctrine, which is a little bit different than sovereign immunity, developed in one of the seminal cases for the active state doctrine in the US is Banco Sabatino versus Cuba, which was an expropriation case. It was an investor-state dispute. It was a case where the investor said, the sovereign government has expropriated my assets. And the US courts said it's inappropriate for us to sit in judgment of the acts of a foreign sovereign on its own soil, and they threw the case out of court. Now that was probably the right result as a matter of US law, but it doesn't leave the investor with a very clear path for another forum to get its day in court. So national court litigation had some limitations, and even if you could find a forum in one or the other venues, your claims would be limited to alleging violation of national law, contract law, administrative law, but not public international law, because generally national courts don't have jurisdiction to simply apply free-floating doctrines of public international law. Diplomatic protection had serious limitations as well. It was optional for the state. An investor has probably a very limited chance of success getting its own government to adopt its claims and elevate them to a very public, very political state-to-state dispute. Maybe if you are the dominant company in the country and you have the kind of political ties necessary to exercise that leverage on your own government, it's a possibility. But for most investors, the chance of getting the government to do that is pretty limited. And even if you're successful, you then lose control over your own case. It becomes a claim owned by your government. They can settle it at will. They can trade it off against other items on their broader international agenda, human rights issues, arms deals, trade deals, anything else that they have on their diplomatic agenda, you lose complete control of. It also, as a matter of international law, requires exhaustion of local remedies, meaning the investor cannot even ask for help from its home government until it has fully exhausted all of its remedies in the host state's courts, which gets you back to the issues of neutrality and process we talked about before. So these peaceable mechanisms were not really working. And investment arbitration developed as a response to the drawbacks of the existing alternatives. The investor is given a direct right of suit against a foreign state without having to invoke the power of its home state in a neutral forum without sovereign immunity as a bar. But the tribunal's jurisdiction is strictly limited by a state's prior offer of consent. And if the state has not previously offered to play in this sandbox, it cannot be sued. Protecting access to neutral arbitration was believed to be a necessary tool to contribute to the development of the rule of law in places where it perhaps was not that well established, and also to encourage foreign investment in the post-war period where foreign investment was seen as a key path to economic development in the developing world. And there were various processes developed, but the one that perhaps has been most successful was under the 1966 ICSID Convention. ICSID stands for the Convention on Settlement of Investment Disputes between States and Investors of Other States. And it provides one type of arbitration process, but it doesn't itself establish jurisdiction in any particular dispute. It's essentially sets up an arbitration institution like the American Arbitration Institution or the International Chamber of Commerce. It sets up a set of rules, but before that set of rules can be invoked, you have to have had separate consent by the sovereign governments through a separate instrument, not through the ICSID Convention. And just very briefly, there are three different ways that can happen. You can have a concession agreement, a contract between the investor and the state directly, which provides for international arbitration as the dispute resolution mechanism. You can have national investment laws, unilateral action by the sovereign government that basically says, if you make a qualified investment in our state and we violate some of the following standards of treatment we promised you, you can bring us to arbitration. Or third, you can have international treaties, and that has become the primary source of action in the field. Over the last 50 years, 180 countries have entered into more than 3,000 bilateral and multilateral treaties that provide investment protection, and the vast majority of those have some kind of access to arbitration. The US is a party to about 50 of these treaties. European countries are a party to more than 1,400 of these treaties. So just a very brief recap, differences between commercial arbitration, which you may study at school, and investment arbitration. Commercial arbitration, the parties are private sector entities or they're governmental entities acting in a commercial or private capacity. Investment arbitrations, they're a sovereign state acting as a sovereign state and a foreign investor in that state. Commercial arbitration, the dispute is commercial in nature and it's usually based on a breach of contract or a violation of national law. Investor-state arbitration is all about public international law, treaty obligations. And finally, in commercial arbitration, national courts are key. They have supervisory authority over the process, and they have the ability to confirm or set aside the award. And in investment arbitration, depending which venue is chosen, national courts may have a lesser role or no role at all. In the interest of time, I'm not going to dwell more on how a case gets to investor-state arbitration, except to say there are a number of threshold hurdles. The investor has to prove that it is a qualifying investor covered by the scope of the state's prior consent, that it's made the type of investment that's covered by a treaty, that it's complaining about state action that post-dated the date of consent, so post-dated a treaty coming into force, or otherwise falls within an exception to the non-retroactivity of treaties, and that the dispute falls within a general class of disputes that the state has consented to submit to arbitration. If the investor can get over those threshold hurdles, then it can claim breach of a number of types of treaty obligations, which you see listed on the slide, and I'm going to whiz through them really briefly. But the commonality here is that the claims are all for monetary damages, not for injunctive relief. So a claimant cannot bring a claim asking a state to set aside its legislation or its regulatory action. It can, however, seek damages for that, and we'll talk about that when we get to some of the criticisms of the system. So time, as I said, doesn't permit me to really go into each of these standards. I'm going to whiz through the slides here. Suffice it to say, they're not designed in any event to allow tribunals to second-guess policy decisions as such, or to penalize states for imperfect implementation of their policy choices. The focus, first of all, of the fair and equitable treatment, which is one of the prongs in these treaties, is whether a state's action was reasonably related to a rational policy goal and was not completely arbitrary, motivated by abuse, motivated by discrimination, for example. That's one of the focuses. Another treaty standard called full protection and security requires states to take reasonable measures to protect foreign investment against foreseeable harm by third parties. And again, the focus is on reasonableness. It's a due diligence standard. Question is foreseeability. It's not a strict liability standard. Expropriation will be better known to you, similar to U.S. takings law, similar to similar laws in other countries. Basically, states are authorized to nationalize or to expropriate property. That is not in and of itself illegal, but there are certain conditions that they have to fulfill, including the requirement that a taking be for a public purpose and not private venality by state officials, that it be in a non-discriminatory way. They're not singling out a particular investor for an ill motive. It's conducted in accordance with due process under home state law, and that it's accompanied by prompt, adequate, and effective compensation. And the compensation requirement reflects a policy choice about burden sharing even for justified takings, that taxpayers as a whole should share the costs and not just the one investor whose property is seized. And the other conditions reflect the notion of deterrence against unjustified or unlawful acts. So there are treaty standards about that. There are a variety of treaty standards about discrimination of against investors based on their nationality. And then there are treaty terms that talk about observance of commitments, where the state has made a specific pledge to an investor of a specific type of treatment. For example, a stabilization clause in a contract. The state has said, as to you, the following tax regime will apply for 10 years. A specific pledge to a specific investor. Sometimes a treaty will make it a breach of treaty obligations to violate those underlying contractual assurances. That's a very brief pass through. And so if those are the types of standards you see in these treaties, a quick word about the process for enforcing them. Claimants generally can allege a violation of these standards in one of two fora. They can proceed before ICSID, that's the acronym I mentioned before, the one that popped up on the Good Wife in 2011. It's an affiliate of the World Bank, based in Washington, though it has offices elsewhere. It's established by an international treaty convention that has 151 signatory states. But claimants don't have to use that mechanism at all. Alternatively, they can bring ad hoc arbitration proceedings under rules established by the United Nations, and then either proceed without any kind of institutional administration or ask a number of other possible institutions to administer, such as the Permanent Court of Arbitration at The Hague, or some other. And there are various differences depending which path is pursued. I'm not going to get into them. Depending which one is followed, there'll be different procedural rules. There'll be different mechanisms for challenging the award. There'll be different enforcement regimes. But the one commonality, no matter which path is pursued, is that the governing law of the merits remains international law, not the domestic law of the investor or the domestic law of the host state. Those can be relevant as a matter of fact in a dispute, but they're not dispositive of whether a state violated a treaty obligation. States can violate their domestic law without committing an international law violation, and correspondingly, they can be home free under their domestic law and still commit an international law violation in certain circumstances. So that's a very quick overview of what investment arbitration is. And so the question is, how did it get to where it is today, which, as we've seen, is a source of some real controversy? So just briefly, a few facts about what I call the childhood years, because they're worthwhile to explore. So as I mentioned, 151 states have agreed to a structure for arbitration at a World Bank affiliate. All the countries that are blue on this map, the ones in yellow, like Russia, signed but didn't yet ratify the convention. The ones in gray have not signed or signed and then withdrew. You'll see Mexico as one of the non-signers, but Mexico actually agreed to use the ICSID structure through a separate instrument in a number of treaties like NAFTA. And so Mexico actually is a very active player in this field despite not formally being a convention party. Brazil and India are obviously two of the big outliers. They never signed on to investor-state arbitration, but that doesn't mean that Brazilian companies, for example, haven't been using the system. They've invoked the benefits of the system on a number of occasions by structuring their investments through the Netherlands or through other signatory countries, and then trying to use that creative tax structuring to basically get the benefits of the system anyway. So the map is a little bit artificial. It shows which states have signed the convention, but it doesn't show which companies in the world have used the system. Now remember the point I made about how obscure this system was 20 years ago when I first heard about it. During a job interview, and this chart reinforces the point. In the first 20 years after this convention was signed, which was in the mid-1960s, there were roughly 20 cases in total over 20 years. The next 20 years, from the mid-'80s to the mid-2000s, there were about 180 cases in total, a ninefold increase. And then starting around 2002, we've seen more than 20 a year, and in many cases, more than 30 or 40 a year. So if you discard the very early years where there were just a handful of cases, the real action has been in the last 20 years in this field. Roughly 2/3 of the cases have arisen under bilateral treaties, another 10% or so under multilateral treaties like the Energy Charter Treaty or NAFTA, and then another 18% or so rely on consent from contracts, another 9% on consent in investment laws. Who is getting sued? In terms of the cases at the World Bank affiliate, and remember that's not the only sandbox, roughly a quarter of them have involved respondents from South America. That's largely a function of a few key events, moments in history that resulted in a lot of different suits, like the pacification measures that Argentina adopted during the 2001 financial crisis, or Venezuela's nationalization of key sectors of its economy, which is what came up in the Good Wife episode in 2011. More recently, the filings have really picked up against states in Eastern Europe and Central America. If you look at this chart, one thing is a little misleading. It looks like only 4% of the cases have been against North American parties, the US, Mexico, and Canada, generally under NAFTA. But there have actually been more NAFTA cases than that. They just, for various reasons, have mostly gone through the non-World Bank avenue, UNCITRAL, and I explained that Mexico has consented to that. And so there actually have been more cases than you see in this chart. Many of the cases arise from large infrastructure projects, oil and gas, electricity, hydro, solar, but also transportation, construction, information, banking, tourism, various other fields. What about the outcomes? Roughly a third of these cases go away before decision. It's a mistake to assume that those are all settlements, meaning a state has coughed up either money or a change in its laws to make the case go away. A lot of cases are withdrawn by the claimants. After the state files a strong response, the claimant realizes it's unlikely to win, it doesn't want to keep throwing money after it, and a bunch of cases get dismissed for failure of the claimant to pay its administrative fees. So you can't really draw inferences about the cases that go away. They go away for all sorts of reasons. But on the roughly 2/3 of cases that actually get decided, about 54% of those end up with a state victory, either on jurisdiction or on the merits. 46% find for the investor in some fashion, but some of those are very partial victories. One claim out of 7, a few $1,000,000 in damages against a claim of several $100 million of damages. So some of those wins are actually considered by the investor as losses. Some of those losses are actually considered by the state as wins. Again, you have to look at a particular case to sort of figure out who won and lost. Those are just the ICSID statistics. I'm not going to spend time on this slide looking at cases outside of ICSID, but the message is basically the same. Roughly a 60-40 outcome in favor of states. And it's worth noting that those outcomes are in the context of disputes brought by an older generation of treaties, mostly treaties signed in the 1980s and the 1990s, which, as I'll talk about, are considered to have fairly investor-friendly protections. They're not the new generation of treaties. And by the way, relevant to the debate between Senator Warren and President Obama, I'll mention that there have been 13 cases brought to judgment against the U.S. in the 3 decades since the U.S. has been a party to NAFTA. And the U.S. has never lost an ISDS case. So what do we see in this case? Despite the increase in filings over the last 20 years, there's still a very limited body of jurisprudence. And that's not surprising. Some cases, as we've seen, go away without a decision. Many cases are still pending. Small set of decided cases by which to judge the track record thus far of a system. I'll contrast this with national systems of jurisprudence in the US, in any of the other countries that you may hail from. They generally develop their jurisprudence over hundreds of years, and they benefit from interpretation of a core body of common instruments, a constitution or statutes. Here the instruments themselves vary. We have 3,000 different governing instruments, and they also generally benefit from a system of stare decisis, of binding judicial precedent. And here, this system doesn't have that. So given its relevant infancy, it's 20 years old in terms of jurisprudence, and the lack of binding precedent, you would expect the decisions to be all across the board. If you take a historical view, it's actually remarkable how much consensus already has developed in a very, very short period of time in key issues. Certain issues that were novel when I and my colleagues argued them 15 years ago are now considered settled law. Nobody argues about them anymore. Doesn't mean there aren't new issues. There is still a lot of dynamism in the jurisprudence, which makes this a fun area of law to be an advocate in. But it's actually amazing how quickly a jurisprudence constante is developing, considering it's a 20-year-old system. So all that brings us to where we are today, which I call the teenage years. I have two sons, they're 19 and 22, and I know all about the teenage years. Any parent knows that with those sort of spotty and gawky years of rapid growth comes a degree of self-doubt. And the real question as parents is that just the normal angst of growing up? Is that just a passage that you need to go through to confidence and to maturity? Or is that an existential crisis? So let us do a very quick spin around the globe and see what's happening today with investor-state dispute settlement. South America, Venezuela, Ecuador, Bolivia, they've all withdrawn from the ICSID Convention, but with a couple of exceptions, they have not withdrawn from these many, many treaties that they've signed, meaning that they're still consenting to investor-state arbitration through the United Nations rules, the UNCITRAL rules. So the objection is not to investor-state arbitration as such, it's to doing it in front of the World Bank from South America. Other countries in South America, Chile, Colombia, Argentina, interestingly, despite the fact that it's been sued many times, are still active players. They have not withdrawn at all. In Europe, the real debate is whether investor-state arbitration makes sense for intra-EU disputes, claims by a European investor against another European state. The European Commission takes the position that that's really not appropriate because the European Court of Justice has similar standards. And so there's debate in Europe about whether intra-EU disputes should be carved out. That doesn't necessarily address the reciprocity issue where you have, sorry, I should back up and say that those who are most strongly articulating that view are those from the very developed systems of law, principally Germany, who are basically saying our courts are good, any foreign investor should be happy in our courts, fine as far as it goes, but it doesn't address the reciprocity issue of what happens when investors run into problems in some of the newer EU states where the rule of law or the judicial system may be more open to flux. In a provincial court in Romania, for example, not to pick on Romania, but in any case, one has to think about reciprocity issues. Elsewhere, the story is different. The prior Australian government expressed concern about ISDS, but the new Australian government has reversed it and has signed on, for example, in a recent bilateral treaty with Korea and a couple of other treaties, has re-upped for investor-state arbitration. China has had a huge reversal in its position over the last decade or so. It used to be a net importer of foreign capital, and so Chinese treaties showed very limited access to investor-state arbitration, generally just for the amount of compensation in cases of flat-out expropriation. As China has become a very active exporter of capital to Latin America, to Africa, to less developed parts of Asia, China's treaty negotiators have now become among the most investor-friendly in promoting broad protections for their investors. So you see an ebb and flow around the world. Where does that leave us? The most common criticisms of investor-state arbitration are the ones you see on the slide. With respect to the very first one, which is about outcomes, is this a system that's stacked against states? The statistics don't bear that out, as I've shown you. The second concern, which is about regulatory chill, is hard to empirically assess. I certainly can't rule it out, but we simply don't know, and I'm not sure how we would know, whether states would be taking different measures if they weren't worried about being brought to arbitration for their measures. How do you assess that? The third through fifth criticisms are ones I'm going to talk about one by one. But those are basically a function of older style treaties with vaguer standards and a decentralized system with 3,000 different versions of standards and an ad hoc adjudication mechanism without appellate review for errors of law. And all of those concerns are solvable by states. States designed this system in the ICSID Convention and through this network of 3,000 treaties, and states can change it. These are not intractable problems. The final criticism has generational implications for all of you. And that is, I think, the most thorny issue, the question of who decides. And that one requires attention from stakeholders beyond just treaty negotiators because they can't solve it themselves. And I'll turn to that one last. So very briefly, the good thing is that there's a very active dialogue right now about how to change the system. There are many, many stakeholders from NGOs to treaty negotiators to arbitrators to counsel. Some of the debate is entrenched. There are some people who are calling to just scrap the system entirely and others calling to defend the castle. But fortunately, a lot of the debate is turning on nuanced issues of constructive improvement. What can be done to reform? And I show this. This is 5 seconds of shameless product placement, which my publisher likes me to do, just to say that one can write a book about the topic. I did, other people did. And the great thing about the jurisprudence now is you have so many different people all coming forward with constructive ideas. There are a couple of different paths forward here to what I call mature adulthood. Let's take them in turn. And I'll skip forward pretty quickly here. The first path is that states can try to replace these 3,000 bilateral treaties with a much smaller network of multilateral treaties. Or they can at least update the older ones with newer ones with more standardized terms. That would lead to less disparity of outcomes. That would address the issue that there's lack of predictability or lack of consistency. That process is already underway with the TPP, with the CETA, the Canada-EU trade agreement, with the debates about the TTIP, which would be a European-US treaty. The idea here is if you have fewer different treaties, you're going to have more standardization of standards, if you will, more clear rules of the road. Now, in addition to standardizing the standards, states can be more specific about what the standards mean. Earlier model treaties, particularly in Europe, were 3 pages long. Very vague terms like fair and equitable treatment, which is largely in the eye of the beholder, and which forced arbitrators to do the best they could with an amorphous standard. The newer treaties are 30, 40 pages long. They have annexes, they have footnotes, they have definition sections. They look like they were drafted by American lawyers who love footnotes, and in fact, they are largely derived from earlier US models. Those may make them longer to read as class assignments, but they actually are very helpful both to counsel and to arbitrators, and most importantly to the stakeholders who have the disputes, because the greater specificity removes the ambiguity with which we all have to grapple, gives less ambit for discretion by arbitrators, and therefore less room for criticizing arbitrators for running amok. And it gives more predictability to states about what is permissible and what is impermissible activity. But note, however, that development is only going to work if, with newer treaties, you get rid of the older treaties. No matter how specific the newer generation of treaties are, so long as the older treaties remain in force, you're still going to have multiplicity of outcomes, and you're still going to have some ill-defined standards. And that is a challenge for states because it takes some time to terminate treaties. They have sunset provisions, but they need to start doing it if that's what they want. Just as I skip through the detailed discussion of the standards, I'm going to skip through these couple of slides, but suffice it to say that in addition to being more specific, the newer treaties are actually becoming more protective of state autonomy, making it much, much harder to sue states. And we see that in a variety of different provisions, which I'm not going to get into here. Transparency. Another thing that the new treaties do is increase transparency. One of the common complaints is about secret tribunals. In fact, investor-state arbitration awards are almost always public. All you have to do is go to Google, and you can read just about any of them you want. There has been an increased move to making the actual filings public during the course of the arbitration, so you don't have to wait to the award. NAFTA, DR-CAFTA, number of other treaties already do that. The UNCITRAL rules have been revised by the UN to make that the default presumption rather than the reverse. Strangely enough, even where the cases are open to the public, nobody attends. The World Bank has made available large rooms with closed caption so that people can actually, after all the uproar about secret tribunals, come, watch, be there. Nobody shows up. And that's probably because watching lawyers drone on for days on end is not very interesting. But the fact is the system is evolving to deal with that concern. The harder issue is about third-party participation, rather third-party observance. When can NGOs, for example, have their views taken into account? And that the rules are developing to deal with, but it's not as simple an issue as it might appear. It has consequences in terms of the parties' control of the issues, time, cost, politicization of disputes. And basically, is this system based on a dispute resolution model where we have parties with a dispute, they control the dispute, they get it resolved, or is it a rulemaking type of process where we want many voices outside of the direct stakeholders to be heard? Whose arbitration is it anyway? Those are tricky issues. The hardest part, and where I'll more or less end up, is the who decides question. Arbitral tribunals are traditionally ad hoc. The investor appoints one arbitrator, the state appoints one arbitrator, and together, or with the help of an institution, there's generally an agreement reached on the chairman of the tribunal. But those three arbitrators don't bind the next set of three arbitrators. And that leads to a concern about usual suspects. Everyone's appointing the same people. Investors are appointing people that they think will find in favor of investors. States are appointing people that they think are biased in favor of states. There's this repeat player syndrome, and there's a concern about closed minds or issue conflicts. Now, I will say that this doesn't come up in the judicial context. The fact that a judge has interpreted the Constitution before or has interpreted a statute before doesn't disqualify them from doing so again. In fact, it's considered the hallmark of an experienced and wise judge. It's a function of the ad hoc system where each tribunal is supposed to be deciding based on the arguments of the parties before them. And the idea is that the parties are supposed to own the process rather than the judges owning the process. It's very different than national court systems. Who has been deciding thus far? Well, if you look at the exit cases, you see a dominance of Western Europeans and American arbitrators. But what's very interesting is if you divide the statistics up between those appointed by the disputing parties and those appointed by the institutions, you see it's the disputing parties who are going to the usual suspects geographically. When the institutions actually have to make a default appointee, they're looking at a more diverse pool in terms of gender, a more diverse pool in terms of ethnicity, national origin. It's counsel who are basically taking the safe route out and appointing on behalf of their clients someone they can say, I've read his or her 20 last decisions, and therefore I can predict how he or she will rule in the next case. So the institutions have limited control over that. They're being very proactive, but the onus is on parties and counsel to take the risk of new names. At the same time, however, we see two different reactions to the limited pool of decision makers, and they're coming in two different directions. From many corners, including the developing world, we quite rightly see a greater demand for diversity. But at the same time, from other corners of the world, and particularly in Europe, we're seeing a demand for greater centralization of decision making. The EU proposal in the TTIP negotiations, which is with the US, is for a standing investment court. Not an ad hoc system, but standing court of 15 judges appointed by states, no appointments by the investors, and the judges would be reappointed after their first term. That presents challenges, not just for diversity, who are the states going to give this power to, but also for independence. David Rivkin, who's the current president of the IBA, the International Bar Association, has noted that if if a small number of people have lifetime, who are appointed to all these cases and they're not given lifetime tenure, they're subject to reappointment by the same states who put them on the roster the first time. How do you ensure their independence when the very nature of the disputes they're deciding are disputes that have binding effect for other states to follow, and they're disputes against states, and thereafter possibly against the states that appointed them? These are all the right questions. And a need for improvement is resulting in a very healthy debate. I don't think that the fact that we're having this debate and that it's hitting the front pages and it's hitting the late night comedy shows means the system is in its death throes. I think it means it's healthy. We've had enough of experience now to know what the right questions are to ask. The process has only been around essentially for 20 years. There's no national system of laws in the world that has everything ironed out perfectly after 20 years. The real question is, what are the alternatives? For those who say the system is fatally flawed and it should be scrapped, in favor of what? And so I'd like to close by recalling the words of Winston Churchill in 1947 when he was talking about democracy. And he said, "No one pretends that democracy is perfect or all-wise. It's been said that it's the worst form of government except for all the others which have been tried from time to time." And so for those who would condemn investor-state arbitration for its flaws, and I don't excuse those flaws, I just view them as a challenge. For those who would condemn the system, I say, would you prefer instead to resign even legitimate investor grievances to the local courts of host states with no international law standards, no neutrality, no system of review? Would you remove the barriers of sovereign immunity so investors can haul foreign states into their own courts? Or would you subject these disputes again to the political wills and whims of the diplomatic protection system and state-to-state horse trading? Which of those systems do you prefer? It's really easy to find fault with the status quo, and the challenge for critics is to come up with better alternatives. So that's where I'll end. We have about 10 minutes. I'd be happy to take any of your questions. Yeah.
Please identify yourself.
My name is Mushek. I'm from the LLM class. You talked just briefly about one of the hottest topics in international treaty arbitration, about the most favored nation principle, and whether the states, if their investment treaty does not have a most favored, if it has a most favored national principle but doesn't have an arbitration clause, can you leverage from the other treaty which have an arbitration clause? I'll be interested to hear your view, if you can leverage from that.
I mentioned before that there are some areas where the jurisprudence has evolved to a rough consensus and others where it has not. And you've put your finger on one of the really hot topics. MFN clauses are an area where there really has been a development of two quite polar opposites of doctrine with no consensus yet. There are those who say, just to back up, we're talking about treaty provisions that say the investor is entitled to treatment no less favorable than that given a third country's investor. And there are those who say, well, the package of treatment that a state affords any investor includes the treatment it gets under investment protection treaties. And if you view that as part of the package of treatment, why should a state be able to give a smoother path to arbitration or a broader path to arbitration for French investors than it does for Brazilian investors? We need an equal playing field for jurisdiction as well. There are those who say that. There are others who say that would eliminate all of the flexibility that negotiators have in negotiating each new treaty. If anything they negotiate not only could be overridden by earlier or later treaties, but could be invoked by anybody in the world, they really don't have the capacity to evolve treaties, for example, to have newer generations of treaties with tougher standards, because investors could always invoke the older treaties. You're asking my view, and I'm going to cop out of that a little bit, in part because I sit as an arbitrator in investor-state cases, and this is not the appropriate forum for me to tell you my views on it. But I will say that it is one of the really thorny issues today, and we don't yet have a consensus. To a large extent, 10 years from now, it won't be an issue, because the newer generation of treaties are telling arbitrators what the treaty negotiators want. For the most part, the treaty negotiators are saying, We don't want MFN to be used to expand access to arbitration. And so to the extent that trend continues, arbitrators will follow that trend. The challenge is arbitrators who are sitting with the older treaties. So that's, okay, we had, yeah, you with the white shirt. Okay, yeah.
Thank you very much. My name is Yusinas. I'm also from LLM class. I have a question about alternatives to investment arbitration. European Commission pretends that they have an alternative. What do you think? Who will win in Europe, European Commission or investment treaty arbitration?
Well, I can't say who will win because I am not an expert in European politics, and this has become intensely political. I think the European Commission has some valid points with regard to intra-EU disputes. And particularly, we've seen a number of cases, a number of which I was actually involved in directly, where you had, for example, state aid decisions by the European antitrust authorities, and the investors brought arbitration claims trying to overrule the state aid decisions. Where you have a internal body of courts with internal standards, I think there is an argument for a carve-out. The harder question, I think, is the trend in Europe to try to narrow the path to arbitration even for disputes that are not internal European disputes. As I said before, for example, the German politicians saying German courts are great, so we don't need in-treaty arbitration. Well, what happens when a German company goes to some other country? Reciprocity is the hallmark. We've seen waves in Australia. The Australian government was dead set against this until the Australian government changed. I think it takes time. It's easier politically to come out swinging against something than to take a nuanced, careful, cautious approach at reforming something. That doesn't make sexy headlines. But I think over time, I'm an optimist. I think we'll move more in the path of reform and less throw the baby out with the bathwater. But we'll see. Let me take one over here. Yeah.
Thank you very much. My name is Zheng Yuan. I'm a 1LJD student. You probably briefly mentioned this in the very beginning, how private law firms play their role in such kind of international investment arbitration. But I was just wondering if you could tell us more about how the role of private law firms changed in the past several decades in this kind of arbitration, and what do you think will be the future perspectives on this?
Okay, I only have a couple minutes, so I'm not going to give a full view of private practice in the field. But both investors and states are hiring outside counsel to pursue these disputes. It used to be a very small group of law firms in New York, London, Washington, Paris that specialized in the dispute. More and more, we're seeing specialization in many, many other countries. One of my colleagues in the audience, Kyung-Hwa Chung, was a Korean lawyer who worked with me on one case, and there are a lot of firms in Korea that are developing this expertise. There are a lot of firms in Latin America that are developing this expertise. Some countries are choosing to defend themselves entirely in-house. The US and Canada don't hire outside firms. They have stable bodies of lawyers that do their own work. Spain is doing the same thing now with a raft of cases. I think there will be work in private law firms for a long time to come. But I think the universe of firms that get a piece of that work is going to be much more diverse. I'd like to think that there'll be enough work to go around. I don't think that's the case. These are very highly sought after areas of practice. It will remain very competitive, but it won't go away. Probably have time just for one or two more. Yeah.
Thank you for coming, Joshua from the LLM program. And I think you're absolutely right in mentioning that arbitrators are probably the biggest issue that's going on in international investment arbitration right now. Just 2 points. The first point is really just a comment. Earlier you said national courts face the same issues that arbitration tribunals have, but of course judges can't become counsel the next day and remain judges for the following case. So there's a slight difference in conflicts of interest when it comes to that small group of arbitrators that deal with investment state arbitrations. My second point is you've painted quite a bleak picture about where we go, because you say there's no alternative, and that's absolutely right. I mean, Professor Paulson has written about moral hazards, then Chief Justice Menon gave his speech in ICA, and then now David Rifkin has given his HKIAC speech pointing out that there's a lot of problems with arbitrators, and recently there are issues about ghostwriting awards. So is there really nothing else? I mean, is there no alternative, and therefore people can actually rest comfortably in the fact that they can get away with most things that...
Well, I didn't say there was no alternative. I said there was no perfect alternative. Obviously, we can go back to a system of national courts, by all means. But it's going to be very hard to get jurisdiction over cases, and some investors may worry about the neutrality of the courts. So it's not an ideal solution, it's a solution. It's the one, for example, that is popular in Europe now. You bring it all back to our courts. So there are alternatives. They're flawed, just as this is flawed. Your first question, though, is a very good one. I do worry about the revolving door of counsel, arbitrator, and investor-state arbitration. And I say that somewhat against interest, because I have sat as both arbitrator and counsel in investment treaty arbitration. There are rules being developed that make it a little bit clearer what the lines are. As a practical matter, it's very hard to assess who has an open mind and who doesn't have an open mind. You can evaluate relationships, you can evaluate repeat appointments, you can have ample disclosure, and you should have ample disclosure of everything that a potential arbitrator has done in the field, so that the parties can assess whether they want him or her to sit on their case. Disclosure is fundamental, but you can't assess, do they have an open mind, do they have a closed mind? I think the challenge is generational. When people get to the point where they're respected enough in the field that they are getting enough arbitrator appointments that they don't need counsel work to feed their children, they can just become full-time arbitrators. More power to them. But then you're going to have full arbitrators as a very small, very old pool of people. If you want younger voices, if you want an increased pool, you need to have a pathway into arbitrator work from younger attorneys. Are they supposed to quit their private practice when they get their very first appointment? They'll go bankrupt pretty quickly. Are they supposed to quit on their second appointment? There is a transitional period. And during that transitional period, there will be a need for soft law and soft standards to govern behavior. Yeah. Maybe one more. There was a hand around here that kept coming up. We'll do you, because I lost my other hand, and then we'll stop.
Hi, I'm Jian I'm Wang Nao here. So I'm just curious, from your personal experience, how hard it is to enforce such an award against a state, especially when a state is not very famous for its rule of law?
Good question. I'm going to distinguish between enforcement and collection. Enforcement, normally in the commercial arbitration world, connotes recognition, legitimization, giving something the same authority as a national court judgment. If you go the ICSID route, you skip over that. The ICSID Convention has a provision which requires all 151 signatory states to give to a final ICSID award the same value that they would give to a final decision of the highest courts of their own land. So an ICSID award is like 151 Supreme Court judgments. It cannot be challenged as right or wrong in the national courts. So it is enforceable instantly. There is an internal annulment process, an internal review process within ICSID, but once you're done with that, once it's final within the arbitration process, it is a final court judgment. Collection, however, is not governed by the ICSID Convention. That continues to be governed by national law. So there's always the challenge, find assets, where do the assets live, go to the national courts, try to get those assets attached if the state is involuntarily paying the judgment. And you are always going to have the problem of, are those assets sovereign assets or are they commercial assets? And that is governed by the national laws of every country as they are court judgments. It's no harder and no easier than it would be getting a court judgment against the state. The difference is that most states pay their investor state judgments. Despite the headlines about Argentina dragging its heels, for example, the vast majority of states pay. And in part, it's because states want the reputation of being rule of law states. They may fight vigorously to defend themselves, but at the end of the day, if they lose in a final court judgment to which they're bound as a matter of treaty commitment, if they flout that, they're then viewed as a non-rule of law state. And they want to encourage continuing investment. And the moment they stop honoring their treaty commitments, that becomes a problem. So most states do pay. It's actually a pretty good track record. I've gone over. I apologize. You have to get to class. Thank you for having me.